Hi, I'm Mark Westcott. Today, once again, I'm with Peter McKnoulty, a consultant with McKnoulty Robertson, one of the leading law firms in estate planning in Australia. The issue that I often mention to clients is the concept of the Anna Nicole syndrome. And once I mention those words, most men and women go into a cold sweat when they recall the case of the young, good-looking girl who married the 75-year-old multi-billionaire. And they try and put themselves in those shoes to see what would happen in their own situation if something went wrong with their marriage. And Peter, I guess my question today is that with a large number of clients going through second marriages, blended families and so on, there's some real issues, aren't there, in regard to both personal and business estate and succession planning. I just wondered if you'd like to talk about some of those issues and how you make sure they're protected.
Sure, yeah, okay, thanks Mark. Look, yes, there's no doubt that divorce is a very common thing these days. I think the latest statistics I saw suggested 50% of first marriages and 60% of second marriages fail. So it's something we really need to think about. And so when you're doing your will, you need to protect as much as possible to ensure that the estate is going to go where you want it to go. And so we often suggest the use of family trusts, and that's to protect even the assets going to a spouse on the death, because it's on someone's death, because it's quite common for a spouse to remarry these days. And so I guess that's even not in a divorce situation. But in that case, if someone was wanting to protect assets against the next spouse of their spouse, then the best way to do that is a trust. And you need to look at then at the control of that trust. So it might be, rather than just being the spouse, it might be the spouse and a trusted advisor or another family member or someone who's going to make sure that the trust fund doesn't go to the new spouse. And the same situation applies when leaving assets to children. It's a slightly different consideration there, because obviously no one wants to have assets being lost in a divorce situation like that, and so we quite often use testamentary trusts in the next generation as well. And it's a difficult trade-off then. If the best protection in that sort of a situation, if there are a number of children, would be to have one trust which none of those children control, and that trust is then available, I guess, for the benefit of all of the children. It's less likely then to be attacked in a family court situation. I've got to say though, the family court is flexing its muscles in this area, and they're trust busting a lot more than they used to, particularly in the last 5 or so years. And so even a properly constructed testamentary trust might still be subject to challenge. But you've still got a level of protection there, and I think you do the best you can. The choice then, of course, is if you've got a situation where, say, there's 3 children, whether you have 3 trusts, one for each of the children, or whether you have one trust which is controlled collectively. In the latter situation, you've got less chance of it being challenged by the family court, but then at the same time it's less flexible and less of benefit for the kids. So there's a real trade-off there. Requires, again, a lot of discussion and proper advice on the situation and the circumstance that suits you best.
Thanks, Pete. Thanks for your comments.
Pleasure.